Should we alive? So please go ahead.
Yes. So, good evening to all of you. Today's topic is there is the 13th enactment which I am dealing with. The Dissolution of Muslim Marriages Act of 1939. Among Muslims in India, we follow the Hanafi law, and as far as Muslim women are concerned, their plight is very, very precarious because they do not have enough education, they do not have any wherewithal, they do not have any money for their maintenance, and multiple wives are permissible, or polygamy is permissible among Muslims. And even today, in some of the pockets, Muslim women especially are suffering a lot, and their emancipation is absolutely necessary. So, with this object in view, the Dissolution of Muslim Marriages Act of 1939 was passed. Here, the Hanafi court, enabling a Muslim woman to obtain a decree from the court of dissolving her marriage in case her husband neglects to maintain her and makes her life miserable by deserting or persistently ill-treating her or absconds, leaving her unprotected. Then, for and under circumstances, gradually the woman, in what cases, in many cases, a Muslim woman can obtain decree. The ulemas also issued fatwas supporting non-dissolution of marriage, an act to consolidate and clarify the provisions to this act. So the Dissolution of Muslim Marriages Act of 1939 was passed because here we follow the Hanafi law, and here the Muslim woman to obtain a decree was almost next to impossibility. Here, sometimes what used to happen is the woman is treated cruelly, the woman is deserted, she is left to the winds, she has no maintenance, she cannot keep her body and soul together, and also there are certain circumstances where the husband absconds from the jurisdiction of the court and deserts his wife. So, in order to consolidate and in order to make the provisions clear and to clear it from the fatwas and clear it from the misrule of the ulemas who are ruling the roost as far as Muslim marriages are concerned, this act was passed. So, to ameliorate the lives of the Muslim woman, to see that the woman is protected, the woman is maintained properly, the woman can keep her body and soul together, she can guard herself against the absconding of the husband, and she can also guard herself against the ill treatment meted out to her during her married life, and also to see that she has something to fall upon to maintain her body and soul together. This act, called the Dissolution of Muslim Marriages Act of 1939, was passed. Section 2 prescribes the grounds on which the divorce can be obtained. One is whereabouts of the husband not known for 4 years. The husband has absconded. God only knows where he has gone. In spite of the best efforts, the husband cannot be traced. And for 4 continuous years, his whereabouts are not known. Then a Muslim woman can apply for dissolution of marriage under the Act. That is Section 2, Clause 1. Then second one is when the husband is guilty of neglecting or ill-treating the wife, or he is not providing maintenance to the woman for a continuous period of 2 years. First one is where his whereabouts are not known for the years of 4 years. Second one is where he has neglected to maintain his wife or provide maintenance for 2 continuous years. And third one is the husband has been sentenced for 7 years. He has been guilty of capital punishment, either for murder or attempt to murder, or whatever it may be, and he has to undergo imprisonment for 7 years. Then, in that case, this is one of the grounds for asking for dissolution of marriage by a Muslim woman. Fourth one is non-performance of marital obligations for 3 years. What do you mean by marital obligations? I think 90% of you are married. You know what are the marital obligations that the husband has got towards the wife. And for 3 years, there is absolutely no consummation. There is no conjugal relationship. There is no sexual relationship. and for a continuous period of 3 years, a woman has been kept away from sexual intercourse, then in that case, it's one of the grounds for dissolution of a Muslim marriage. Then fourth one is impotence. The fourth one is non. But the fourth one is husband has been sentenced for 7 years, where he has undergone a where he is undergoing a capital punishment of 7 years, where he has been found guilty of murder or any other offense which is punishable for 7 years or more. Then next one is impotency. Impotency means where he is not able to perform his sexual obligations. Then where he has been rendered absolutely unfit for marital relationship, that is one of the grounds for seeking for dissolution of marriage by a Muslim woman. Then insanity or suffering from leprosy, that is a person is suffering from mental illness, or is suffering from leprosy, or is suffering from a venereal disease, or is suffering from a communicable disease, or is suffering from a disease which cannot be cured at all, then that is one of the grounds on which a Muslim woman can ask for divorce. Then the Muslim woman was married before attaining the age of 15 years, which is a prohibited age. She can ask for dissolution of marriage. She has been induced into the marriage by the parents of the husband or by her parents. Then on that ground that she is not capable of getting married before attaining the age of 18 years, then it is one of the grounds for asking for dissolution. The next one is woman. Next one is attempts to drive her to prostitution, where he induces his wife to lead an immoral life and also leads her to a brothel den, and he compels her to perform services to other than the husband. Then in this case, it is one of the grounds for asking for dissolution of marriage. And next one is attempts to drive up. Then next one is disposes of her property or failure to have to access. That is, suppose the wife has got property, then he disposes of the wife's property or never allows her to enjoy her own property which stands in her name. It is one of the grounds for dissolution. Then next one is obstructs her to follow religious practices. Please remember, Muslims are very, very pious. They are supposed to perform namaz at least 5 times a day. Though women in Sunnis are not allowed to go to the mosque, but they can perform the religious practices by sitting at home and reciting the namaz. But suppose she is prevented from reciting the namaz or performing her religious prayers or religious practices, it is one of the grounds where a Muslim woman can ask for dissolution of marriage. Then if he has more wives, does not, please remember, sometimes that's the bane of a Muslim. Please remember, I have no aspersions against Muslims. A Muslim can take more than 4 wives, but please remember, he has to treat all the wives equally. But of course, we have to be grateful to Nizam. He used to treat all the wives equally. The question is, if he does not treat her properly, he treats us as a maid servant, or he does not give the position of a wife, respect for a wife, or he does not perform conjugal functions which are expected of a husband towards his wife, then in that case, the wife can ask for dissolution. Then next one is no decree till the sentence has become final. But here there is an exception made, sir. Suppose even assuming a person has been convicted for 7 years, but please remember, he has got a right of appeal, he has got a right to go to the Supreme Court, he has right to ask for clemency also for the President of India. Till all those remedies are open, the question of that 7 years period does not arise. Then not affected by that is not effective till, you have to wait for 6 months till it becomes final. You cannot dissolve the marriage immediately. Then husband has to, but please remember, an option has been given to the husband to prove potency within 6 months, within 1 year. That is, husband can get himself treated. He can take medicines. He can go to the best doctor possible, treating what is called sexual impotency, and then get cured. And 1 year grace period is given. And the court also waits for 1 year period till he proves his potency. No dissolution decree can be passed. Then section 3 is suppose, let us say, the husband against whom the dissolution proceedings are taken had died during the filing. After the filing of the claim, a notice can be given to the relatives to furnish their names, addresses, and place where they reside, and the relationship with they have got with the deceased, and shall have those persons will have a right to be heard as far as the proceedings are concerned. Then effect of conversion. Please remember, conversion by itself does not give you a ground for asking for dissolution. Only thing is sometimes it so happens I've never seen a Hindu getting a Muslim getting converted to Hindus. But as far as a Muslim woman, a Hindu woman is concerned, if she has to marry a Muslim, first and foremost she has to do is she must get converted into Islam. And if she does not get converted, she is not entitled to marriage. But one example I can give you, sir, the famous cricketer Nawab Pataudi, who married a very famous heroine called Sharmila Tagore. Sharmila Tagore never got converted into Muslims. She remained, still her name is Sharmila Tagore in the records. But yeah, even Nawab Pataudi never compelled her to become a Muslim. But conversion by itself to another community is not a ground for asking for dissolution. But one thing is this: suppose a lady gets converted into Islam, and thereafter she has rethinking. She renunciates Islam and comes back to Hindu fold. Then in that case, it may not be a ground for the husband to ask for divorce. Then next one is dower. What do you mean by dower, sir? Dower is a customary right recognized among Muslims. What is the amount payable by a Muslim husband to the wife in consideration of marriage? It is a deferred amount which can be paid immediately or which can be paid later. But under no circumstances, dower can be avoided even if dissolution is made. The husband is duty bound to pay the dower amount or the meher amount to the wife in consideration of marriage as laid down in the Siyanama. That is what section 5 says. Then what happened was slowly dissolution started, and there was what is called a clamor among Muslims that their rights will have to be protected. So, why this happened? Because of the famous Shabanu's case, where the Honorable Supreme Court laid down certain guidelines where they said restricted the wife's right for maintenance only to the extent of 3 months, that is iddat period, 3 menstrual periods as they used to call it. Then Muslim women revolted against it. They wanted the act to be amended, and this led to the passing of the Muslim Women Amendment Act, Protection of Rights of Women, Divorce Act, 1986. Here, in Shabanu's case, it was held that a divorce of a Muslim wife is entitled for maintenance from her husband under Section 125 CRPC, so long as she does not remarry. Wife includes a woman not consummated, and held that Section 127 3b is violative of Article 14 of the Constitution. It created a lot of stir, and therefore this act was followed. In Shavanu's case, what was held was marriage was not consummated. They did not have sexual intercourse. The nuptial night, the walima, ended in a failure. This lady was Shabanu was deserted by her husband. She was left on the crossroads of starvation and penury. The husband did not bother to pay her maintenance. Then what happened was she was literally begging on the streets. She brought an action against her husband for maintenance under 125 CRPC. But as far as the Supreme Court in this case held that the enforcement of maintenance order under 127 3b is not enforceable and it is violative of Article 14 of the Constitution, and therefore they restricted the claim of the woman only to the extent of 3 months maintenance or what is called the iddat period. And this led to a lot of confusion, and this led to a lot of commotion among the Muslim women, and they clamored for the amendment of the act. In 1986, the Union government enacted the law called the Muslim Women's Amendment Act, Protection of Women's Rights under the Divorce Act 1986. Under this act, 128 CRPC not enforceable as against the husband. One of the leading cases in that aspect is 1990. Please note down the citation, please. 1990, 1990, 1990 bracket 1, 1990 bracket 1, ALT 1990 bracket 1 ALT 360. That was a case of Muslim Advocates Forum, Muslim Advocates Forum versus Usman Khan. Muslim Advocates Forum versus Usman Khan. A Muslim, in this case, what happened was Section 128 not enforceable as against the husband. Here it said a Muslim divorced woman is entitled to here. So they followed the Shabanu's case and said a Muslim woman is entitled only to 3 months maintenance, that is the iddat period maintenance, whether she marries or remarries or does not do so. And this led to a lot of confusion. This led to a lot of dissatisfaction among women, and women were clamoring for the amendment of the Dissolution of Muslim Marriages Act, and thereby the Muslim Women Amendment Act of 1986 was passed, whereby they say a Muslim woman is entitled to a reasonable and fair provision for maintenance for her and her children. And her children, a Muslim woman divorced, unable to maintain herself, the magistrate can order maintenance up to 2 years. So in Shabanu's case, what was held, sir? In Shabanu's case, it was said a Muslim woman who is divorced from her husband is entitled only for the iddat period maintenance. That is 3 months period maintenance alone she can claim. And they also said that the question is beyond 3 months she cannot claim. Of course, she was entitled for the meher amount or the dower amount. Beyond 3 months, she was not entitled to claim maintenance. But this particular amendment, which was brought to the Muslim Dissolution of Muslim Marriages Act, protected the woman and said the magistrate has got the discretion to award maintenance for a continuous period of 2 years, and thereby Shabanu's case was absolutely diluted and annulled by this amendment. Then Section 2 says a divorced woman in that period, the lunar months after divorce, the period between the divorce and delivering of the child of pregnancy, whichever is earlier. Here they gave two options. They said iddat period maintenance. Second one is they said 3 lunar months, that is the menstrual periods. And the next one they said if the child is in the womb of the mother, the period for which the child is in the womb of the mother plus 2 years was the period that was allowed as maintenance. So this was a revolutionary step which was brought about by the amendment to to the Dissolution of Marriage Act, Dissolution of Muslim Marriages Act. But other meher and other things remains intact. Then order for payment of maintenance, then option to be governed by 125, affidavit to be filed that they are bound by 125 to 128. The deferred, that is disposed according to law, Sakil Bhai versus Fakhruddin. There is it says applicable to wife and not by husband. Then it is said not maintainable, so on and so. So in short, Shahbanu's case was nothing but Muslim women were discriminated irrespective of their marital status, irrespective of consummation or non-consummation. Second thing is the Shahbanu's case said 125 CRPC to 128 CRPC governing the law relating to maintenance is not applicable to a Muslim woman. She is only entitled for 3 months maintenance, that is the iddat period maintenance, 3 menstrual periods or 3 lunar months for which she is entitled. But this Shahbanu's case led to a lot of controversy, which led to the amendment of the Muslim Divorced Women Act 1986. Protection was given to the woman, where the magistrate can apply Section 125 CRPC and award maintenance for a continuous period of 2 years, and the husband is bound to maintain the wife or the child which is born out of the marriage for a period of 2 years. And this was one of the drastic revolutionary changes which was brought about in the personal law of Muslims. But the question arises, the question is the option that is subject to an option being given by the wife that she is going to be governed by 125 to 128, an affidavit to this effect has to be filed. So in other words, this act came as an emancipation of the rights of the woman, whereby a woman can claim maintenance for a continuous period of 2 years, and that Shahbanu's case is no longer a good law as far as Muslims are concerned. Of course, this Amendment Act brought into existence decisions from the Congress party itself. One of the prominent members of the Congress party, who is now the governor of Kerala, I think if I'm correct, his name is Arif Muhammad Khan, resigned from the Congress, revolting against the amendment, and then joined the BJP. But the question arises, after that also the Modi government brought about a law whereby whereby triple talaq is today abolished. Triple talaq is no longer available as far as Muslims are concerned. So these are all this is a very, very small enactment. But the judgment in Shahbanu's case created ripples among Muslim women. They clamored for more rights. They clamored for more, what is called, sustainability and more credibility, and also to keep their body and soul together. That is the reason the magistrate is now empowered to apply 125 to 128 CRPC. I'm talking about the old law. Now it's 145. Well, I think it must be 145 to 148 of the BNSS. The question is, even if the child is in the womb of the mother, and as soon as it is delivered, 2 years period maintenance has to be given by the husband to the wife. And other rights like meher and dower has to be paid by the husband, irrespective of the dissolution or not. So this is as far as a very, very small enactment called the Muslim Dissolution of Muslim Marriages Act of uh, of 1939 as amended in 1986. Even today, you know that as far as this community is concerned, is opposing the Uniform Civil Code. Please remember, Uniform Civil Code is not operative as on today, except among Hindus. Even among Christians, it is not followed. But India, Christians are governed by various enactments. But as far as Hindus are concerned, they are governed by the Hindu law. But as far as Muslims are concerned, uniform civil law does not apply to them. I can also give you the genesis why uniform civil law could not have been implemented earlier. Because if you see every enactment, this act applies to the entire territories of India except the state of Jammu and Kashmir. Because Jammu and Kashmir was a princely state earlier under a Maharaja. It was subsequently acceded to the Indian Union. And Article 370, when the Kashmir the ruler handed over power to the Union government, 370 was enacted, whereby they said, as far as people residing in Jammu and Kashmir are concerned, they are entitled for a special status, and the constitution does not apply as far as J&K is concerned. Then, of course, when Modi came to power, the first thing he did, I think it was last year or last before year, Article 370 of the Constitution is now repealed, whereby the Jammu and Kashmir also, the entire Constitution applies to Kashmir also. And please remember, under the Constitution in Jammu and Kashmir, an outsider cannot own property. But today, after Article 370 has been removed, even an outsider can own property in Jammu and Kashmir. These are the far-reaching changes which has been brought about by the repeal of Article 370 of the Constitution. Of course, the far cry is Uniform Civil Code. Uniform Civil Code, I do not know so long as we live whether it's going to come into existence or not. But for the emancipation of women, to see that they are properly maintained, see that they are not abandoned, see that they are not driven to poverty, see that their children are taken care of properly. A need is very much essential, where we must have a uniform law as far as all communities are concerned. This is not a political view, please. This is what I honestly believe. Yes. So this is as far as the Muslim Marriages Act, Dissolution of Muslim Marriages Act of 1939 and the Amendment Act of 1986. Please note it down, please. Till now we have completed 13 subjects as far as civil law is concerned. Guardian and what? Guardian and what? Then we go on to the 14th topic called the Guardian and Wards Act 1890. Guardian and Wards Act 1890. Guardian and Wards Act 1890. First and foremost is we must know the alphabets of the law, of the subject. First and foremost is, first definition which is given is, who is a minor? Minor is a person who has not attained the age of 18 years. He is supposed to be a duly incapax. He is unable to understand the implications of what he is doing or what he is supposed to do. And a minor is not responsible in law, either in torts or in contracts. That's the cardinal rule. And a minor who has not attained, a person who has not attained the age of 18 years is supposed to be a minor. Then second one definition is that ward. What do you mean by ward? Ward means a minor. Ward means a minor. A person who has not attained the age of 18 years, who is of tender age, is called a ward. Under the Guardian and Wards Act, he is not called a Guardian and Minors Act, but it's called Guardian and Wards Act. That is a law governing the custody, maintenance, upkeep, and hold over the persons who are of tender age. Second one, ward means a person who has not attained the age of 18 years. Third one is guardian. Who is a guardian? Guardian means in Urdu it is called the wali, a person who is given the custody of a child who has not attained the age of 18 years, who is a ward or who is a minor. Such a person who has got the custody of the property as well as the person of the minor is called a guardian. And guardians are of various types. Guardian is natural guardian. Natural guardian of a ward is normally the father or the mother. And as far as males are concerned, among Hindus, till 7 years, the father is the natural guardian of a male child. But as far as the female child is concerned, the female child, the guardianship remains or the custody remains with the mother till the child attains the age of puberty. Are you able to understand, please? Then the question is a person who has a custody of the child, custody of the minor, custody of the minor is called a guardian. Then there are second guardian also. Suppose a minor has no guardian. Suppose let us say the estate is administered by the collector. Then the collector is the guardian as far as the child is concerned. Third one is a testamentary guardian. Who is a testamentary guardian? A guardian appointed by the deceased, in whomsoever's name it may be, to take custody of the child, look after him, look after his maintenance, look after his education, look after his property, and who is appointed under the terms and conditions of a will. He is called a testamentary guardian. Fourth type of guardian is a person who has no parents, he has no relatives. Then in that case, the court appoints a guardian. An advocate is appointed as a guardian who has to look after the interests of the minor and they look after the property of the minor and collect the rents out of the property and remit the rents from time to time and then render proper accounts. He is called a court guardian. So these are the four types of guardians which you can contemplate under the law. Then, as far as India is concerned, we are as a patriarchal society. That means we go after our father. We have also our surname and the village name or the place where we are born from the father's side. And only exception, I think, perhaps, is Chennai. After Jayalalitha came to power, they say that you can always have your name as, mother's name can be put as son of so-and-so. But here in Hyderabad and other places, still you call yourself as a son of so-and-so. Your father's name alone is given as a son of so-and-so. So the question is, here guardian means a person who has got the custody of the minor, a person who has got the custody of the property belonging to the minor, a person who administers the property of the minor, a person who manages the property of his minor. These all called guardian. Then we go to the subject in the proper perspective. Then appointment and declaration of guardian. The welfare of the minor is the prime consideration to be appointed as guardian and declare him as guardian. Section 7 says the court has got the power to look into the who is to be the proper guardian. Least among the paramount interest should be the welfare of the minor, the advancement of the minor, the management of the minor, not only the management of the person, as well as the property of the minor, then in that case, the welfare of the minor is the prime consideration as far as appointing him or her as the proper guardian. And naturally, that's the reason, sir, the court takes all the circumstances into consideration before deciding who should be appointed as guardian. Then, it entitled to person who can file a petition. A person, a section 8 says, a person desirous of being the minor, being the guardian, relative, collector. First of all, a person who is interested to act as a guardian of the minor. It can be the mother, it can be the father. And suppose, Yadamokom Pedamokom antaru చూడండి. The question is, suppose the husband and wife are not getting on well together. Welfare of the minor is involved. Advancement of the minor is involved. He has to see a lot of things in life. Then normally the preference is given to the parental, to the father's, that is the father's side. There is a grandfather and grandmother can be appointed as natural guardian. They can file an application to give the various reasons, and they can file an application before the court to declare them as guardian of the minor concerned. It need not be the father, it need not be the mother, but preference is normally given to the father's side because ours is a patriarchal society where the father is given more power rather than the mother. This arises when the father and mother are not getting on well. They are facing a matrimonial proceeding. The child is not looked after properly. The child's welfare is important. Advancement of the minor is involved, and the maintenance of the minor is involved. Maintenance of property of the minor is involved. So, in all those circumstances, since we go by the patriarchal society, the parents of the father can act as the guardian of the minor. Then, second one is relative. Any relative who is interested in the minor, any relative who has got the upper interest of the minor as the uppermost objective, and they can also file an application to declare themselves as a guardian. Then collector, when the child has no relatives near or far, either on the mother's side or on the father's side, the collector looks after the child and he can be declared as the guardian of the property, guardian of the person as well as the property. Then, sir, what is the form in which a guardianship petition has to be filed? That is what section 10 postulates. One is name, address. First and foremost is, normally the question is, before we go into that, we must know the jurisdiction, sir. Here, section 9 says jurisdiction. Normally, the jurisdiction, or what do you exactly mean by jurisdiction? Jurisdiction means authority of the court to entertain an application for guardianship. It is called the GNWOP. GNWOP means guardian and wards OP. Under section 9, it is said that as far as where the minor resides, where the parents reside, where the person applying resides, where the minor is actually located, or which is the court which has got jurisdiction. Normally, it is a principal district court which has got jurisdiction to entertain applications under the GNW Act. But nowadays, what is happening is they are filing petitions before the family court also. The question is, normally, family courts nowadays, they are rejecting petitions filed under the Guardian and Wards Act. They say, go to the district court. We have no right to entertain your application. So, wherever the minor resides, wherever the minor's custody is, whoever has got the custody, where that person has got the custody of the child, that principal district court has got jurisdiction to entertain a proceeding under the GNW Act. Then section 10 stipulates what is the format in which a GNW petition has to be filed. First and foremost is to say petition for appointment of guardian or the person of the minor under section 10 of the Guardian and Wards Act. You underline it in the court of the principal district court, city civil court, Hyderabad or Secunderabad, as the case may be. Then all OPs under the Guardian and Wards Act are numbered as GWOP. GWOP means Guardian and Wards Original Petition, number of whichever year it is. Then you give the name of the parties. The person who is applying to be appointed as a guardian is a petitioner. His name, address, and description, and occupation, and residence you mentioned. He is called the petitioner. And normally, suppose let us say the husband and wife are living separately, then the name of the wife, her address, her occupation, residence has to be mentioned. and second one is all concerned. Then you make them as respondents. Then down you say petition for appointment of guardian under section 10. A guardian of the then in the down you say in re appointment. In re means in the reference of application to appoint the guardian under section of the person of the minor so and so, aged so and so, under section 10 of the Guardian and Wards Act. Then we come to the topic proper. First, I think most of you know how you write name and address and description of the petitioner, name, address, and description of the respondents. Third one is address for service. When you are appearing, you give your address. Fourth, service. Water. Fourth one is the address for service of the respondent. You say it is the same as given above in the past item. Then we come to the brief facts of the case. That the petitioner is the respondent is the legally wedded wife of the petitioner, having been married to him on so and so date at so and so place, and the marriage certificate is filed herewith and marked so and so. Next paragraph. After the marriage, the petitioner and the respondent started living in house number so and so, situated at so and so, and subsequently a male child by name so and so, age so and so, was born to the respondent through the petitioner on so and so date, and the minor child is presently in the custody of the respondent. Right? Next paragraph will be that subsequently differences and disputes arose between the petitioner and the respondent, and they are living separately in different homes, and they are not living together, and the child is presently in the custody of the respondent at so and so place. Full stop. Then you say the minor whose custody is sought for is only aged so and so years, and is incapable of maintaining himself, and I have got enough resources, enough financial background, and I can maintain the son in a proper way and get him properly educated and well placed in life, and therefore it is in the interest and welfare of the minor that I should be appointed as the guardian of the minor concerned. Next paragraph, you say that due to the differences and disputes between the parties, the minor is not looked after properly, and his welfare and education or maintenance is in turmoil, and therefore, and the respondent has no independent means of livelihood or any property or time to look after the minor, and therefore it is for the interest of the minor that the custody of the minor person has to be entrusted to the petitioner, and hence this petition is filed for the the petitioner being appointed as the guardian of the person of the minor so and so, age so and so. Next paragraph. Subsequently, the petitioner through his lawyer's note dated so and so called upon the respondent to hand over the minor child to his custody so that he can be properly educated, properly maintained, properly managed. But the respondent avoided to hand over the custody of the minor child, and therefore the petitioner is constrained to file this petition. On the other hand, the respondent is not properly employed. She does not have the independent means, and she is not a fit person to be appointed as a guardian of the minor. Next paragraph. Apart from the petitioner, the respondent, the minor child has got grandparents by name so and so, and grandparents from the wife's side so and so, and also near relatives. And except the father, who is a petitioner herein, none of them are interested to maintain and manage the minor, and hence the petitioner has no other alternative than to file the present petition to be appointed as the guardian of the person of the minor concerned. Next paragraph. That the minor has a property bearing number so and so, which was purchased in the name of the minor by the petitioner for his welfare, maintenance, and upkeep, and the property is presently managed and administered by the petitioner, and therefore the petitioner, in addition to be appointed as the guardian of the person of the minor, is requesting this honorable court to appoint him as the guardian of the property of the minor situated at so and so. The next paragraph is that the petitioner is a proper and fit person to be appointed as a guardian of the person and of the minor, and it is in the welfare of the minor that the guardianship of the minor should be handed over to the petitioner, and hence this petition. Then you say cause of action for the petition arose on so and so date when the child so and so whose custody is claimed was born, and when the child has been taken away by the respondent and is presently living with his mother in premises number so and so, situated at so and so. The next part, this honorable court has jurisdiction to try this petition as the minor, as the minor last resided with the petitioner in house number so and so within the jurisdiction of this court. Next para is a court fee of rupees dash is paid. Then next one is no petition is filed in respect of the same claim before any court nor any petition is pending. And next one is the petitioner therefore pays for a judgment and decree to be appointed and to be pleased to appoint this honorable court may be pleased to appoint him as a guardian of the person and property of the minor. And then you minor so and so. And next is you say that you sign, and then counsel also signs that verification is there. The place of verification is also mentioned. Then the list of documents which are filed along the petition also has to be mentioned. And then the schedule of property, which where the property stands in the name of the minor, the schedule has to be given, and you as the guardian, a proposed guardian, has to verify that particular paragraph. And then notice has to be issued to the opposite side. Then the opposite side comes, and the opposite side will be heard, and the evidences will be recorded on both sides based on the evidence and the facts on record and the documents submitted. The court comes to the conclusion appointing a person as the guardian of the person and property. But please remember, your responsibilities don't cease when you get yourself appointed. There are a lot of obligations imposed upon you. When you are appointed as the guardian of the minor, it is your duty to administer the property, look after the property, maintain the property, collect the rents out of the property, spend it for the welfare of the minor, and under no circumstances you can alienate it, you can encumber it, you can mortgage it, or charge that property to the detriment of the minor. That is, in other words, the court takes care of the minor's property as a zealous mistress, and then it sees that the minor is not driven to the crossroads of poverty and penury. That is the reason, if suppose, let us say, for the interest of the minor, welfare of the minor, advancement of the minor, a particular property has to be sold belonging to the minor, permission of the court is absolutely essential, and it shall be sold at the higher price. And whatever is the higher price, the price has to be deposited in the court, invested in fixed deposit, and the guardian who is appointed is only interest entitled to draw the interest and keep the maintenance, keep the amount for maintaining the child. But please remember, there may be certain circumstances which arise. Alienation of property is absolutely essential to maintain the child. Then, in that case, you have to seek the permission of the court and say that it is for the welfare of the minor that the property has to be alienated. And even under those circumstances, the court has to be satisfied that it's a genuine reason, and the court permits you to alienate the property, but only on one condition: is the sale consideration has to be kept in deposit with the court till such time the minor attains the age of majority. Then next one is, please remember, it's a very, very small enactment. Suppose, let us say, in under section 12 it is said, suppose a woman is in custody of the child, then you can ask for interim custody of the child for a temporary period till the disposal of the petition. If the court is satisfied for the reasons recorded in an interlocutory application, court can grant interim custody of the child till such time the petition is disposed of. Then, what are the prime conditions that has to be satisfied in a petition for guardianship? One is welfare of the minor, upkeep of the minor, education of the minor, and all this, and the financial background of the respective parties, the desirability to be appointed as a guardian, the qualifications of a person who is seeking a guardianship, and the honesty of the person who is seeking the guardianship. All these factors will have to be gone into. Then, as far as the guardian is concerned, he is in a fiduciary capacity compared to that of the minor. What do you mean by fiduciary capacity? That means the minor cannot think for himself, he cannot act for himself, he cannot do anything for himself, and the guardian who is appointed is in a dominating position compared to that of the ward, and whatever he does should be of utmost good faith and he shall not let down the minor at any time. That is why it is called the guardian stands in a fiduciary capacity, in a dominating capacity compared to that of the minor. Then then the question arises. Section 21 says, can a minor be appointed as a guardian? Please remember, minor himself is incompetent. How can he apply for guardianship? A minor is unfit, minor is incompetent. Even if he files a petition, that petition will be thrown out at the threshold. Then, as far as court guardian is concerned, suppose the child is an orphan, he has no parents, he has no near relatives, then in that case, the court appoints an advocate as a court guardian who has to safeguard the interest of the minor, administer the property of the minor, and also deposit the rents or profits arising out of the property into the court and draw the quarterly interest for the welfare of the minor. But he has to maintain proper accounts also. Then, as far as if the collector is appointed as a guardian, then in that case he is subject to the control and supervision of the state government. Then, as far as the duties are concerned, the health, education, maintenance of the child has to be maintained at all costs. Then what are the powers of a testamentary guardian, sir? As per testamentary guardian means a guardian who is appointed under a will. Suppose that a testamentary guardian, it cannot mortgage, cannot charge, cannot encumber the property of the minor without a proper permission or order of the court. Then no alienation. So alienation, if you want to alienate the property and it is required for the welfare of the minor, the permission of the court has to be obtained, and only when permission is obtained, you can transfer the property. Then 31 is protection practice with regard to that is permissive transfer without that is, they said, whenever the property is sought to be sold and it belongs to a minor, it has to be sold to the highest bidder. It shall not be sold for a lower price than what it would normally fetch. Then, at any stage, if variation is required, a court can always vary the order. That is what 32 says. Then court's opinion for how the property has to be managed, how the property has to be administered, how the property has to be looked after, what is for the welfare of the minor, the court can give its opinion regarding the management. Then obligations is as far as the person who is managing the property as a guardian has to submit, he has to first, when he is appointed as a guardian regarding the property, he has to give a bond that he shall faithfully discharge his duties. And under the bond, if he does not do his duties, whatever amount is mentioned in the bond will be recovered from him as if it is arrears of land revenue. Then he has to also submit the statement of immovable, whatever the immovable properties owned and possessed by the minor, and then he has to render proper accounts, and then whatever balance is due under the account, he has to also render for it, and maintenance for education, how much has been spent, how much is still required, all these particulars he has to mention. Then suits against guardian for administration bond was taken. That is, who has the bond? Proper person. That is, suppose let us say bond has been taken for faithful discharge of the duties. Whatever amount is mentioned in the bond will be forfeited in case you neglect to do it. Then if the bond is not taken, you can ask for what is called accounts. Then if a bond is not taken, the person in custody of the child can be asked to render accounts regarding the amounts that have been collected regarding the property of the minor. Then, under what circumstances a guardian can be removed? One is death, failure to perform his incapacity. Then, what is called ill treatment with regard to the provisions in connection with adverse interest. That is, ceasing to reside with the. Please remember, in the bond itself, we should say we shall not move the minor from the place where he is staying. The minor shall remain in the place from where he is originally staying, and he shall not shift the minor to any other place. He shall seek the permission of the court in case he wants to cease. Then he ceases to occupy the property where he is locating, or let us say he has got some adverse interest to that of the minor, he has got some pecuniary interest. Then in that case, in all these cases, or let us say he treats the child with cruelly, or he metes out ill treatment to the child, then he has incapacity because of physical and mental illness, or he dies, or he failure to perform his obligations, then in that case he can be removed from guardianship. Okay, suppose, let us say, suppose some other property is acquired after the, that is, it said, cannot be removed if the adverse interest accrued after the death of the person who appointed him. Suppose, let us say, in a testamentary transfer, suppose, let us say, some other property comes to his hands, then in that case, it is not adverse interest. He cannot be disqualified, he cannot be removed. Then right of survivorship. Suppose, let us say, there are two joint guardians. Then in that case, one of the guardian dies, the other guardian survives. Then the guardianship rests with that person, and the institution of guardianship will not cease. Then section 40 deals with what is called discharge. Discharge means where resignation for his that is sufficient reasons for his discharge. Suppose he suffers insolvency, suppose he becomes bankrupt, or suppose he is convicted, or in other reasons he resigns from the post of guardianship, then he can be discharged from his guardianship. The next one is, when does the guardianship cease? It ceases when the minor attains the age of majority. Automatically, guardian goes out. Then supplemental proceeding says, relate the conduct of the proceeding, penalty for removal. Suppose, let us say, the guardian is removed from the custody, from the jurisdiction of the court where he was originally residing. Then in that particular case, the question is, he can be punished to the extent of 1,000 rupees or imprisonment also. This finishes the small chapter called Guardian and Wars Act of 1890. So along with this, I repeat, we have completed 14 civil subjects. And the next in the agenda is we will deal with the Contracts Act in the proper perspective. Please remember, Contracts Act contains about 239 sections. I want the full attendance as far as Contracts Act is concerned, because Contracts Act has got an importance as far as our real civil practice is concerned. It is the mother of all acts, and without Contracts Act, mercantile law doesn't exist. And please remember, at least for the benefit of those, I have been repeating the subjects again and again. But as far as Contracts Act is concerned, it is not possible for me to repeat, and I'll be going at a very slow pace. But we will definitely go according to how you understand. If you don't understand, kindly ask it in interaction period so that I can clear it immediately. Thank you.
Good evening, all. As per sir instructions, I am talking as of now. But what kind of we have about 2,000 members, more than 2,000 members who are in the group, in different kinds of groups. But unfair is that we have a very less number of participants in Zoom. And in Zoom and in other aspects, 100% attendance, 100% viewership is coming for us. I agree that we are busy, but as sir is asking for the Contract Act to be started, so I request everybody to get participate in the Contract Act.
No repetition.
There will not be any further repetition in this particular subject. Please make sure that you attend the class, because the interaction section will be detailedly explained when you ask any kind of questions, because it will be a mother of every act. Please do understand, and please use an opportunity so that it will come to a conclusion. I hope everybody understands this. Is there any questions? Vasantra Garu, please go ahead, sir. Just a second. Please unmute yourself and go ahead, sir. Go ahead, sir.
Good evening, sir. Are you hearing me, sir?
You are audible, sir. Please go ahead, sir.
Sir, for dissolution of Muslim marriage, which court has jurisdiction, sir?
It is, as far as Muslims are concerned, it is the district court, sir. District court includes family court also.
Earlier, my senior filed a dissolution of marriage with junior civil judge court, sir.
Pardon?
The junior civil judge court has jurisdiction.
No, sir. And now everything has been made out to family court. Junior court cannot decide about family matters.
Sir, it is the dissolution of marriage act. It's nothing but a declaration of to marriage the null and void or the dissolution marriage.
Declaration that marriage is dissolved and null and void, sir.
That's why section 14 that the Union Civil Code and judicial, in my opinion.
No, sir. It's only family court. Under the Family Court Act, all matters relating to family. They don't say Hindus, Muslims, and all. For everyone, family court applies, or in the principal district court.
So where the family court does not exist,
It does not exist. There is a sub court.
Sub court.
Yes, sir.
Okay.
And it is numbered as OS, not as OP.
Yeah.
Right. Any more questions, Mr. Sir? Please go ahead with the question.
Sir, namaste.
Please be a bit loud. You are not audible, sir. Please be a bit loud.
Sir, namaste, sir.
Namaste.
You are audible now.
సార్ అదే ఇప్పుడు చెప్పారు కదా ముస్లిమ్స్ కి డిజల్యూషన్ ఆఫ్ మ్యారేజ్ కాకుండా డైవర్స్ కి ఏమైనా ఎనీ యాక్ట్ ఇస్ దేర్ సార్?
No, sir. There is no act because now after the question, only this act applies, and the latest amendment is the 1986 Muslim Marriages Amendment Act, Protection of Women's Act of 1986. There is no
అంటే రీసెంట్ గా అంటే రీసెంట్
Sir, Raleigh, sir. It is not in the force.
It's a distant dream, sir. Till you get the uniform civil code, that will not happen.
It is not in the force,
Until-
sir.
recently we have filed in family court one petition for declaration of the marriage null and void, sir,
Right.
in Visakhapatnam.
Right.
సో అంటే అది ఎంతవరకు పాసిబిలిటీ ఉంటుంది సార్ అది నల్ అండ్ వైడ్ కి?
Null and void got section 2 కింద మీరు చూడాలి, various grounds are given.
What are the grounds null and void మీరు వేసింది దేని గురించి చేశారు, సార్?
సార్
Null and void దేని గురించి చేశారు మీరు?
అంటే నార్మల్ గా ఏంటంటే వాళ్ళిద్దరి మీద ఇల్లీగల్ ఇల్లిసిటీ ఉందని చెప్పేసి, వైఫ్ కి వేరే వాళ్ళతో ఇల్లీగల్ ఇల్లిసిటీ ఉందని చెప్పేసి.
Okay.
Sir,
బట్ హస్బెండ్ మీరు ఎవరి తరఫు నుంచి ఉన్నారు మీరు?
ఐ ఫర్ హస్బెండ్ సార్.
Sir, the question is illicit intimacy or illicit relations. Easier said than done, sir. It's very, very difficult to prove and establish. You'll have to even, what do you call, if you are the husband, if you have got nowadays the ITS come, you have got any photos or any, sir, even that is not foolproof.
ఓకే సార్.
All right.
And another query, sir, regarding for ఇప్పుడు ఒక ఇండియన్ సార్, కెన్ ఐ ask for sir
Sir,
succession
one
OP
second.
would
No,
be
Indian Succession Act have not come, sir. Hindu Succession Act only have dealt with.
yes అంటే అందరు జనరల్ క్వైరీ సార్ ఇది.
చెప్పండి.
అంటే ఇప్పుడు చిల్డ్రన్ కి పేరెంట్స్ ఎవరు లేరు సార్. సో అయితే గ్రాండ్ పేరెంట్స్ దే ఆర్ అపోజింగ్ సార్. గ్రాండ్ పేరెంట్స్ అపోజ్ చేస్తున్నారు సార్ వాళ్ళకి. అంటే వాళ్ళ ఫాదర్ తాలూకా అమౌంట్ ఏదో ఉంది అది తీసుకోవడానికి గ్రాండ్ పేరెంట్స్ అనే వాళ్ళు అపోజ్ చేస్తున్నారు సార్. అది ఎంతవరకు పాసిబిలిటీ ఉంది కనుక్కో.
Sir, if they are opposing it, the question is then you file a petition to make the nearest relative or maternal grandparents as parties.
మెటర్నల్, నాట్ ఫర్ పెటర్నల్ సార్.
No, first preference paternal. అది లేకపోతే maternal పోవాలి.
ఓకే, అంటే అపోజ్ చేయడానికి అవకాశం ఉంటుంది సార్. అంటే వాళ్ళు పేమెంట్ ఆపండి, పిల్లలకి ఇవ్వాల్సిన అవసరం లేదని చెప్పడానికి బ్యాంకర్స్ కి
ఎట్లా చేస్తారండి? కోర్ట్ విల్ నాట్ పర్మిట్ ఇట్.
సార్ ఓకే సార్, థ్యాంక్ యూ సార్.
Thank you. And Mr. Srinivas, please go ahead with the question, sir.
Good evening, sir.
Good evening.
Sir, my doubt is, you said this Hanafi sect is, it is applicable, that is, dissolution of Muslim Marriage Act is applicable to Hanafi sect.
Yes.
Whereas, I'm confused with the words Shia, Sunnis, and there is one more particular.
It is prevalent in Vijayawada.
Ramesh garu, please mute yourself, sir. Ramesh garu, please mute yourself.
Sir,
Chilpuri. Sir, please go ahead with your question, sir.
sir. My doubt is that sir said it is Hanafi sect, whereas normally in Muslims, Mohammedans, there are certain major sects are in India, Shias, Sunnis, and in Hyderabad there is one more particular variant of Muslims, sir.
It is not in Hyderabad, sir. It is in Vijayawada. They are called sheikhs.
Yeah, that is there. And at times they are in Andhra. They are called Bundalis also, sir. At times.
But all of them are bound by what is called Hanafi law only. Hanafi law only is followed in India.
In Saudi,
Acha, Hanafi. In India, all Muhammadans, all Muslims are covered under Hanafi law.
but as far as Saudi and all are concerned, they are governed by the Sunni Shia law.
Acha, okay, sir. Thank you, sir.
Let us not go into the Shia law. It's quite complicated.
Thank you, sir. Thank you. Thank
Any
you,
more
sir.
questions? Any more questions in this particular subject? Please go ahead. All right. We are concluding it for today, and we're coming up with some counter-attacks. And we need a regular attendance so that you will have an interaction. Just giving a lecture, your zeal. So once you understand, once you understand the subject, if you are coming up with some doubts, you'll have a more clarity on the subject also. I request everybody to get an active participation in the Zoom. Or else, if you are not coming, please make sure that you love to have that particular aspects.
No repetition.
No repetition in the class. Thank you. See you soon. All right.